Hello and welcome to a fresh episode of Legal Wrangle on GST. In today's episode, we will be presenting before you the latest judgments of various high courts involving various provisions of GST. Let us now proceed to our first case. The petitioner company challenged the constitutional validity of Rule 138 Clause 10 of the CGST rules. It alleged that the mandate of Rule 138 Clause 10 ran contrary to the provisions of Article 14, Article 19 Clause 1 Subclause G and 301 of the Constitution of India, since it restricted the validity period of the e-way bill in terms of distance to be travelled in a day.
The petitioner further stated that the circular number 64/38 of 2018 GST dated September 14, 2018 and more particularly clause 5 thereof, which provides that in a case of consignment of goods is accompanied with an invoice or any other specified document and also an e-way bill proceeding under section 129 of the CGST Act may not be initiated.
The petitioner also claimed that the situations enumerated were illustrative and not exhaustive. It was also claimed that a mistake made in writing distance could be deemed to have been included within the ambit of the circular.
On hearing the contentions, the High Court directed that notices be issued to the parties returnable on January 10, 2019. Let us now proceed to the next case.
In this case, an FIR was lodged against the petitioner for allegedly causing loss of revenue to the government by means of false sales and purchases running into crores of rupees. It was also submitted that the petitioner obtained GST registration by using fake documents.
Investigation revealed that the petitioner's firm purchased goods worth about rupees 80 crores and then claimed input tax credit of about rupees 14.3 crores. To show the genuineness of the transaction, the SSE submitted only a few bills, the verification of which revealed that the vehicle used by the petitioner to transport the goods purchased was a Honda Activa scooter. Other illegalities were also pointed out.
In defense, the petitioner claimed that the FIR could not have been registered under Section 420 and 120B of the Indian Penal Code when the alleged offence had been committed under the CGST Act. To counter such argument, the Revenue clarified that provisions of IPC had been invoked to check the rising instances of fake firms and forgery of documents.
Upon hearing the contentions, the High Court did not express any opinion on merits of the case. However, it held that the custodial interrogation of the petitioner was warranted, considering the serious nature of the allegations levelled. With such observations, the writ petition was dismissed. Let's proceed to the next case.
The petitioner was transporting some goods during the period of dispute. However, the goods as well as the vehicle were detained en route as Part B of the accompanying e-way bill had not been filled up. Hence, the Revenue alleged contravention of provisions of Section 138 of the CGST Act.
The petitioner claimed that the transport charges received by it never exceeded rupees 2,000. It was also claimed that the consignor or the consignee were liable to answer for this lapse. The petitioner also took the defence that as per mandate of Section 122, if taxable, goods were transported without cover of documents, such offence would be best in white fine of a maximum of rupees 10,000.
On hearing the contentions, the High Court held that if the petitioner sought the interim release of the goods, it had no recourse except under the provisions of Section 129 of the CGST Act. It was also clarified that the petitioner could not evade proceedings under Section 129 since the provision did not make any exemptions. It was thus observed that Section 129 Clause 1 Subclause B applied to all the persons interested in the goods. The court upheld the legality of the detention notices and directed the petitioner to comply with the mandate of Section 129 Clause 1 Subclause B so as to secure the release of goods. The writ petition was dismissed with such observations. Let us proceed to the next case now.
The petitioner filed the present writ seeking that central government may exempt from charging GST on perfumes and cosmetic products sold to international passengers at airports. The petitioner also sought that it be permitted to claim refund on input tax paid on supplies and services from the retail shop which it intended to set up at the airport.
The main thrust behind the petitioner's contentions was that similar products were being sold to international travelers without attracting customs duty and other applicable taxes such as CGST, SGST or IGST. Hence, the petitioner sought similar benefits and relied on certain judgments to substantiate his case.
The High Court examined the precedents cited and noted that they applied only to supplies to or from the duty-free shops after the passengers crossed the immigration counter beyond customs frontiers. In such case, it noted that the transaction would be said to take place outside India and thus would be a non-taxable supply under Section 2, Clause 78 of the CGST Act. It also clarified that the duty-free shops located at the international airport were deemed to be in non-taxable territory under Section 279 of the Act.
The court further noted that the cases cited by the petitioner were inapplicable to sales, purchases or supplies from shops located in domestic airport or domestic security hold area, both of which are located before the immigration clearance. In such cases, the transaction cannot be deemed to have taken place beyond the custom frontiers of India. Hence, the court dismissed the petition, finding no merits in it. Let us go to the last case.
During the period of dispute, the petitioner, a dealer, had purchased goods in Tamil Nadu and was transporting them to Kerala. The goods were detained in transit by the Assistant State Tax Officer. While the petitioner paid the tax, the penalty imposed but erroneously remitted the same under heading SGST, when in fact such remittance should have been made under the heading IGST. Due to such error committed by the petitioner, the revenue refused to release the goods.
Section 77 of the CGST Act enables refund of tax paid erroneously paid under the wrong head. However, Rule 4 of the GST refund rules provides for adjustment. If an amount of refund is adjusted completely against some outstanding demand, then an order detailing such adjustment must be passed in Part A of Form GST RFD 07. Hence, the High Court observed that the revenue could allow the petitioner's request and transfer the amount from SGST head to IGST. The petitioner cannot be left without remedy merely on the grounds that the same is time-taking. The court noted. It thus directed the revenue to release the goods and the vehicle as well as transfer the tax penalty already remitted to IGST head. This brings us to the end of today's episode of Legal Wrangle. Please stay tuned to www.tioltube.com for our upcoming videos. Please also feel free to share your opinion with us at editor@tiol.in. Thank you for watching and have a nice day.